You're live.
Okay, good afternoon, everyone. I'll call to order the Hillsborough County Land Use Appeals Board for February 4th, 2022. We'll start off with our introductions, and I am Bradley Cordelius. I am the Vice Chair of the Board, and I will be serving as the Chair of the Board today, as Ricky Bauman, our Chair, is not here this afternoon. We also have with us today Mr. Jerry Campbell, a board member, Mr. Justin Evans, a board member, and Mr. Peter Schwartz, also a board member. So we do have a quorum for our meeting today. I think on staff we have Mr. Hisney with Development Services, Ms. Meyer, Citizens Board Support, Mr. Clark, who's Assistant County Attorney, with us at this meeting today. So that's that part. What I'll do now is quickly go through the rules and procedures for today's hearing. We do have one case before us today. So this board is an appellate body and shall only consider the land use hearing officer's decision and the record. This hearing shall be limited to the record on appeal as defined in LDC 10.03.03.H and consists only of limited oral argument based upon said record. No additional evidence may be submitted or considered by board members. Next, the order of presentation it'll be staff's introduction, then the petitioner will provide their case. If there's any opposition, they will then have the opportunity, and then finally rebuttal by the petitioner will be the order of presentations. Only the following folks have the standing to appeal or to intervene in appeal, which is filed or may be heard at this hearing today. So those that have the standing would be the applicant, the administrator, or any person or entity which appeared before the LUHO and provided testimony or other evidence or presented evidence themselves or by proxy to the LUHO and was adversely affected by the decision of the LUHO. Also, the board reserves the right to limit presentation to 10 minutes per side. The time limit may be extended for good cause. Pursuant to this reservation, the presentation is hereby limited to 10 minutes for each side, with rebuttal limited to 5 minutes. The basis for a good cause extension is case reasonable requires additional time. Proposed additional presentation is relevant. Proposed additional presentation is non-cumulative, and amount of time used to answer the board's questions. The board shall have the authority to uphold the land use hearing officer's decision or remand the case back to the land use hearing officer. If the board remands the case back to the land use hearing officer, the board shall specify the reason for the remand and specify the issues for the land use hearing officer to address. The final part is, can I ask the county staff to administer the oath to those that are proposing to provide testimony to the board?
Okay. We're ready for that now? Good morning, all staff who will be testifying must take the oath of witness. Please stand and raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you. Turn to page 2 of your agenda under 1A, new cases, appeal number APP 21-1331. The petition file number is VAR 21-0573. The appellant is Brandon R.E. Holdings, LLC, with his representative Todd Pressman. The property owner is Brandon R.E. Holdings, LLC. The petition request is requesting the variance to the required yard setback and required minimum buffer width and screening standards. Location is 520 East Brandon Boulevard.
Okay, thank you very much. Mr. Hisney, would you like to introduce this item for us?
Yes, this case was heard by the land use hearing officer on July 26th. It requested setback variances and also a buffering and screening variance. The setback variances were approved by the land use hearing officer, but the screening variance was not. Following approval of the variance, a question was raised by the applicant's representative as to whether these variances, the approved setback variances would apply to a redevelopment of the site. Staff's answer was no, it would not, based on the findings in the record by the hearing officer. The applicant then asked the hearing officer for a reconsideration of the matter, and the hearing officer denied that reconsideration. And the applicant then appealed to the Land Use Appeals Board.
Thank you, Mr. Hisney. I guess now what we'll do is we'll move to the petitioner, Mr. Pressman. Would you like to present?
Yes.
Good morning, Mr. Chairman and board members. My name is Todd Pressman, 202nd Avenue South, number 451 in St. Petersburg, Florida. Mr. Chairman and board members, the headline of the premise here is that the LUHO did approve all 6 criteria. Recognize there is a hardship, private property owner of rights, does not interfere with others, that it's in harmony with the code, not done by an illegal act, substantial justice being done. However, the official findings of fact and her conclusions were unsupported by the competent substantial evidence she accepted and basically made a significant mistake. What's at issue here is only about a setback. That's all this is about. And I'm going to walk you through it and then walk you through where the errors and problems were. So going to the overhead, you'll see what was submitted under the application was a side setback and landscape buffer and a 20-foot yard landscape buffer setback. And as indicated, she approved the 17-foot reduction along the north property line, which is important, Mr. Chairman and board members. The second variance is not being contested, it's been complied with, and there's no more code enforcement violation. That's been solved. The second variance is really pretty much the same. It was reduction of the setback where the buffer is, virtually one and the same to reduce the buffer and the setback to 2.5 feet. Both of those were approved. That's critical that all 6 criteria were found. I want to draw your attention to the first page of the recommendation. Applicant is requesting variances to the required yard setback and minimum buffer width for the entire lot line. Nothing else is specified out. This is the site. It's a very thin site located along Brandon Boulevard. It's unusually shallow and has a long history of use. You'll see it's shallow here as compared to all the other large lots, which was precisely accepted specifically by the LUHO officer. A closer view of the lots that are affected. And this is a critical slide. And the hearing officer refers to that. I'm going to show you that we show at this property with a 30-foot front yard setback and the 20-foot side setback that we're seeking to reduce to the 2.5 feet, there's only about 58 feet that are buildable, which she found as a hardship and met all 6 criteria. I'm going to walk you through that in a minute. This is a critical slide because we are asked, as I showed you, for the setback on the entire line of the setback, not at 2 particular points that she worked towards in her, with all due respect, her failed conclusion. And then we showed prior zoning maps to show that the condition existed for a very long time, 73 zoning map and earlier zoning maps. And then we showed some aerials showing that as well. I also made you aware that there was previously concerns submitted to the commissioner's office about noise violation. And we did show that the air division and sound division of Hillsborough County had found no complaint and dismissed those. So turning to the hearing officer, as I showed you critically, what was stated as our request was a setback and buffer reduction for the complete property line, again, because this property is very thin. But here's what happens, Mr. Chairman and board members. When you come to the details of the request that she writes up, she writes it up again. Setback landscape buffer But she notes that for existing commercial structures, which we never submitted for nor never really discussed about having a variance from, this is where the mistake and her conclusion at the end is false. So she states, as we have stated, what the variances are. Along the north property line, the same for the setback and the buffer. But again, the disparity that she, for some reason, states as existing commercial structures up here. And again, the mistake is then continued when she refers to Mr. DeFrank with Development Services, that the applicant's requesting setback for landscape buffer screening for existing commercial structures. As I've showed you on my presentation, that was never directed and never discussed in that capacity whatsoever. That's a mistake that's leading to her false conclusion. Now, she recognizes very clearly the hardship that the developable area is 58.7 feet when the 30 front yard setback and 20 yard setback are applied for the front and the rear, like this, like the slide I showed you. The property is unique in its configuration and size as compared to larger adjacent parcels. She's agreeing with us that the entire lot, not a couple points of a commercial building, are a hardship. She goes into her evidence submitted. Criteria 1, yes, she approves it. The hardship is unique. The subject property is narrow and therefore limits the developable area given the required setbacks and buffer with standards. It's critical that she states that at that point, but at the same time, she set up a false conclusion that only 2 points of a structure on the property is all the setback is for, and that's not right, it's not correct. She's recognizing the entire width of the lot or the entire length of the lot should have the variance. Subject property is narrow, therefore limits the developable area given the required setback buffer and with standards. Criteria 2, yes, again, she approves. She notes, and this is where she starts to carry the error and the conclusion, which is false, unsubstantial evidence that she accepted. The variances for the buffer width and side yard are the result of location of existing commercial building, which was shown to have existed in the prior location. We never discussed about a prior location. We are not asking for a grandfather, and we did not file for non-conforming use. I showed you very clearly what we filed for, and that she, in the prior criterion, accepted the hardship runs for the entire length of the lot, both on the front setback and rear setback. Criteria number 4, yes, she approves again. The variance is in harmony with the LDC and comprehensive plan. Again, as the lot shape constrains the developable area of the commercial building, where she picks up the false premise again, in conflict with exactly what she said under criteria 1. Criteria 5, yes, the lot shape and location of the commercial building existed prior to the purchase of the current property owner. Mr. Chairman and board members, again, we weren't asking for grandfathering. We didn't file for non-conforming use. We filed for a variance, which she supports and recognized the hardship. Bear with me 1 second. Oh, here it is. I'm sorry. You can go back up here, please. Mr. Chairman, board members, the test of this appeal is that the variance approval does not address the recognized and stated by the land use hearing officer, the hardship. It negates and ignores the direct purpose of the variance and the dire necessity for this singular unique lot. Again, what the loophole proved was a grandfathering, NCU, not a variance. We would have filed for it if we were only concerned about the 2 structures. We would have filed for it and done the NCU grandfathering. The variance is absolutely critical to the future viability of this parcel. Like all others in the vicinity, without it, the site is tremendously restricted and not viable. I'll be happy to answer any questions or concerns you might have.
Thank you, Mr. Pressman. Board members, any questions for the applicant? Or yes, sir, Mr. Campbell.
Yes. So you said it's not viable in its existing configuration, but as I read through it, I understood that with the variance that you were given, the existing business with the exception of the screening, which you say you're going to address anyway, the existing structure and the business as it's configured, it's operating that way. So the current business can operate there. It seems to me the argument you're making is that if you want to take that current business out and redevelop the site, bring a new business model in, even with the same owner, that you want that same variance. But when you say it's not viable, it seems to me that the business that's there now, from all intent and reading, and what the complainant says is they've been expanding the business. It seems like the business is good. It's been there since the early 2000s. It seems to me as though what you have on site with these variances is viable. Is that correct?
The point of my presentation, as I indicated, is going by the criteria. Is there a hardship? Yes. Is there a
But
hardship? Is there a hardship? Yes. Going by the criteria. Is there a hardship? Yes, there is. And it's recognized by the hearing officer as the narrow and limited developable. I'm reading directly from her report. The subject property is narrow and therefore limits the developable area given the required setbacks and buffer width standards. She found all 6 criteria for the entire length of the property. We didn't discuss individual 2 little buildings or little shacks on the property for the property to be viable. Viable means that is a property that is able to be developed like others in the immediate vicinity or in the general vicinity. And that's what the hearing officer recognized 100%, and then not negatively went rogue about 2 commercial buildings on site. We are required to stick to the criteria. All 6 criteria were found, and they were found on the basis of the very limited buildable area of 58.7 feet. That's undeniable. That's presented by her word by word. So the test of the variance is, on one hand, she's fully recognizing that this property is, I'm looking for her word, limits the developable area like all other properties in this vicinity because of its shape and configuration. That is a 100% variance built upon topography or shape configuration of a lot. Is the property workable now? The property is able to be worked in a very ragtag fashion, extremely ragtag fashion, with a couple of ragtag buildings that are hardly usable. But that would, again, be an entirely different set of circumstances, entirely different world of a grandfathering or non-conforming use. That doesn't make the property viable. They've had one very interested, as a matter of fact, they've had one very interested developer for the property, which I'm aware of, and he left because they can't build at 58 feet with the setbacks, as they really almost literally destroy the property. The question, with all due respect, is not, is the property viable with 2 single points of setback for 2 sheds? The question is there a damaging element on this property because of the setbacks as compared to others? And the hearing officer writes 100% specifically that it is damaged, that it is affected, that it does have support for variance. I'm sorry if I went on there. I apologize.
Mr. Evans or Mr. Schwartz, any questions? Yes, sir.
So are you seeking the variance for new construction?
Oh. We are seeking and I'm not being evasive, we are seeking a variance that will make this property viable now and primarily in the future. But the way to look at it is not, is it currently viable? The criteria have you put your thoughts directly in the fact, if there is a hardship, is it caused by the applicant? Is it detrimental to others? And she answered yes to all those criteria. She wrote to you that she recognized that the width of the property is very small. I read that to you specifically, and is significantly affected by the two setbacks like no other properties are. So yes, viability into the future is absolutely critical, like any other property along Brandon Boulevard. They cannot even be par with virtually anyone else on Brandon Boulevard as communicated to you by the hearing officer and of course by myself.
Mr. Evans?
Yeah, and I understand what Mr. Pressman is saying about the difference between a legal nonconforming use and a variance. Obviously, legal nonconforming use would have been, the cause for that would have been necessarily the building, that it had been in place for quite some time. He did not present this as based on the building as to the reductions in the buffer or the setbacks. And it appears that the existing building would not be able to accommodate the existing buffer or setbacks along the north side at least. I believe that was cause of code variations or code violations. So the hearing officer, when she had rejected the reconsideration, had done so strictly based on the qualifications for a reconsideration. Mr. Pressman, it's my understanding that you're contesting that, saying that there had been a mistake and that what you had presented as reasons for the variance request were not considered. Is that correct?
That's more or less correct. Yes, sir. That is correct.
Okay. Just want to clarify that. Thank you.
Thank you, sir. Mr. Pressman, this is Brad Cornelius, Chair. Just a couple questions from my perspective looking at this. I do understand exactly what you're saying and your position, but I do have some concerns. As I went through the record, reading the transcript, looking at all this, the information that we had, what I see when I look at the record is the majority of the conversation was about the existing conditions out there and the existing buildings and the impact on the neighbor and the concerns with those. And those were that made up quite a bit of the testimony that from the variance hearing. But the other thing that I think that I see that's really important is when I look at on page 37 of the transcript, where the hearing master does recognize, and the hearing master says, all right, and so frankly, that leads to the question of your motivation to correct these violations because you're leaving. Because, in the testimony that was provided, Mr. Farmer, the owner, did say he's planning to move to another location. And Mr. Farmer's response was not that for a redevelopment, but his response was, well, if something happens and we decide to stay there, something goes wrong with the other contract, we decide to stay there and continue on there, we may have two sites. We're not apt to leaving that for retail. That's one of our suggestions we may want to do. So when I see that, Mr. Pressman, what I take from that is it was about the existing, at least from, I will say, the owner's perspective from this testimony. So I guess where my question comes in is I almost see this as you're not necessarily appealing the LUHO's determination, but you're almost appealing the staff's determination about the LUHO's approval gets implemented. How do you see that? Or did you?
Well, you're absolutely,
Mhm.
Mr. Chairman, you're absolutely correct, because I did spend quite a bit of time with the staff as they made an interpretation about the setback only be for a barn. I went and had a lot of communication with the staff, including Mr. Hisney, and through those discussions, they made it very clear that they felt that the setbacks or the variance approved was only for the barn structure, which does extremely little for the property. So the only recourse that we had, so I did follow that course. The only recourse we had was to submit for an appeal from the land use hearing officer. In regard to discussion of future or current there was discussion of that, and I have a couple frames of that to show the other board members. We showed earlier activity on the lot, 2002, 1999, some earlier year as well. But the purpose of that was to establish that this was not, that the shape of the lot had maintained itself over a long period of time, that it was a viable variance. It wasn't something that property owners had created a very thin lot. Now, I do believe, personal opinion, the hearing officer, the LUHO, took that as some sort of direction about items in the setback, items not in the setback. I didn't present it that way. Mr. Farmer may have made a comment, but I made it very crystal clear in writing on my PowerPoint slides that I showed you. This is about the entire length of the lot. Quote, "The subject property is narrow and therefore limits the developable area," meaning the future and current, "given the required setbacks and buffer width standards." That's item number 1 criteria, which is the most important criteria to be found. So with the greatest respect, Mr. Chairman and board members, the hearing officer has a discrepancy because on one hand, she clearly recognizes the reduced buildable area. At the same time, she goes, again, not negatively, she goes rogue and decides it's going to apply to only one structure, which does not jive with criteria number 1, 2, 3, 4, 5, or 6 that she found. It's not about one structure on the property. It is about the site being viable now and in the future.
Okay. Thank you.
Every other property on Brandon Boulevard, they're not asking for anything more or anything less than anybody on Brandon Boulevard has. This is a definable, 100% clear, presented in writing and pictorially of a credible variance. And that's why she found it for all 6 criteria.
Thank you, Mr. President. I just have, I think, 2 more questions specific here. Now, so the 2.5 foot setback and buffer width variance that were approved, it's my understanding, and can you confirm this with me, that how you got to that request was based on the existing buildings on the site. Is that correct? That's how you got to the 2.5 foot request, or is that not correct?
I'm going to ask you to repeat that. Just be sure I understood it correctly, please.
Yes, sir. Yes, sir. My question is, your request for the 2.5 foot, to allow for the 2.5 foot setback and the 2.5 foot buffer width, which both of those variances were approved. It's my understanding going through the record that how you came up with that specific request for 2.5 feet was based on the location of the existing structure. Is that correct?
No, there were a number of circumstances. One was the existing structures. The other was how much would be a minimum variance. That's a critical factor to any variance, and it's one of the main criteria. What would be the minimum to ask for? So we decided on 2.5 for a number of reasons. First of all, there's an alleyway between this property and the one behind it for 15 feet. Secondly, there were a couple structures there. And third of all was the discussion about, as I indicated, minimum for developable area on the property, because we were not asking for a variance to the front setback. And then additionally, we had a landscape buffer or landscape area we had to provide all along that same border, that north border. So I talked to a number of landscape people about how much width we would need so that the green elements, trees and hedges that would be required to be in there would be sufficient for width. And all those factors came together for 2.5 feet. But I would say probably, not probably, but the most critical consideration was what would be a minimal variance.
Okay, thank you, sir. That's the only question I have. Any other questions for the petitioner at this point? Seeing none, we'll move now. Do we have anyone here there in opposition that would like to speak?
We do have a party here in the audience, so if you'll come up now, sir. And state your name and address.
Certainly. Thank you. Good afternoon. My name is Christopher Brown. I'm here today to speak in opposition regarding the request for an appeal to the LUHO Board's original decision from July 26th for the variance being requested by Brandon RE Holdings, which is located at 520 East Brandon Boulevard. I live at the property abutting to the north side at 111 North Montclair Avenue in Brandon. And with regards to this case, the owners of Brandon RE Holdings, they have for years maintained this property in a state that has not only been in violation of county land development code, specifically with regard to the code enforcement violation, but they've also been a nuisance and detriment to the neighborhood at large, just through their normal day-to-day operations, dealing with RVs, specifically with regards to the lack of the buffering and landscape requirements, is what I'm going to speak about here today. The property to the south side abuts a busy 8-lane Highway 60, Brandon Boulevard. And they also operate a business, again, that comprises as part of their daily operations the maintaining and cleaning of large recreational vehicles. With today, I will go ahead and proceed with going over the reasons for why I believe this request is not only frivolous, but unnecessary and unwarranted. First and foremost, I would like to emphasize that I do completely and wholeheartedly agree with the original decision of the LUHO board on all counts. I'm not here today to state that request that was originally approved for reducing the setback for their existing building should be overturned. I feel that it was fair and equitable, being that it is an existing structure that has lied on the property since the 60s, long before the current owners took possession, and probably prior to the land development code for Hillsborough County, it being enacted in the form in which it is today, that it would have been in conflict with. Of course, it makes sense that there would be a conflict between the two, and that a variance was warranted unless they would be required to demolish the building and start over. I'm not an unreasonable person and realize that exceptions, must be made sometimes in certain circumstances like this. What would be unreasonable, though, would be to request that a variance for the situation that we've described be granted completely and indiscriminately to any future structures that may or may not be constructed on the property without oversight to guarantee compliance with the Hillsborough County Land Development Code. The owners, Mr. Farmer and Mr. Pressman here today, as well as in the previous hearing, state that this is a uniquely shaped parcel, which puts them in a position held by no other property or business owners, which is simply not true. Many businesses along Highway 60 in Brandon share the same dimensions and requirements for screening and buffering, as well as with regards to setback. They are also purporting that the setback and buffering requirements as outlined within the Land Development Code would deprive them of the rights and enjoyment similarly held by their nearby properties, which is also untrue, as the requirements would have and have not have any impact on their day-to-day operations whatsoever, nor has it over the past 15 years since they've taken ownership. As far as the variance that was granted, they are asking this so they can continue to operate in essence without worry of reprisal or penalty. Granting this request, though, for future immunity from county oversight, ultimately for any planned structures that may possibly conceive of would in fact negatively impact me, my family, and the residents of the neighborhood as a whole. This would eliminate our rights to the enjoyment of our property by way of unnecessarily subjecting us to structures that could be potentially and uniquely situated in a manner not congruent to that of the Highway 60 district as a whole. This could not only include the structure itself, but any other byproducts, noise or light pollution as well. This request, if approved, though, it would be unique in that it would not fit with the reason that the code is in existence to begin with. The code was not only enacted to provide consistency in standards, but so as to preserve the harmony and enjoyment of one property as well as to preserve the same for others. It's also clearly designed to help guide and shape new structures when they are built so as to maintain consistent standards and so that there is not a situation where there are potentially two drastically different structures abutting one another. If this appeal was granted, you would be giving this power away from yourselves to the current or any future owners of the property, which would be completely antithetical to the very reason for the Land Development Code and why it was enacted in the first place. I please ask that you do not do this. At this time, Mr. Farmer, the owner, and Mr. Pressman have not brought forth sufficient reasons to justify the request for this variance to be granted. The unique status of them being grandfathered into perpetuity, in essence. What they have done, though, is stated their intentions to sell the property. In fact, they currently have a coming soon sign located on the Highway 60 frontage of the property promoting a Woody's Wash Shack. Mr. Farmer stated that the LUHO hearing in July that they've begun construction of a new location and intended to be moving operations within 6 months to a year. We are now within that time frame, and they are yet to finalize the move or construction of their new location. I do believe that this variance, though, in all honesty, is a non-issue for the current owners, Mr. Farmer, who with such a move coming would need not worry about such matters. That would not have any impact on him whatsoever moving forward. And that is, in fact, something better left to the new property owners if and when that transition would take place. In fact, this has already solved an existing issue for Mr. Farmer, taking him from a situation where he was in a status of non-compliance with the LDC to being in compliance with it. And if the new property owners feel that a variance is warranted to accommodate whatever structure they are planning on constructing, then they can go through the same process of submitting a site plan for review and approval like every other business that wishes to operate in Hillsborough County. It's not unreasonable to expect everyone to have to go through the same process as checks and balances, much like the one Mr. Farmer recently went through with regards to gaining approval of the plans of their new location. Also, at this time, I would like to go back to something Mr. Pressman said in the original Luho hearing on the 26th, and I quote, I would say with all due respect to the neighbor, and I do mean with all due respect, perspective-wise, that when you choose to live at a site that is less than a stone throw from State Route 60, you're going to have impacts from commercial activity. First and foremost, I did not choose to live at my current residence, nor next to their business. The property was originally purchased by my great-grandparents in the 1930s as a partition to what was then a poultry farm. In fact, the site of the property in question was actually owned by them.
Sorry, sir, sir, hang on. I need to interject real quickly. Board members, I understand what the gentleman is addressing is comments that Mr. Preston made at the original hearing. My concern is that any response to anything Mr. Pressman said that's new and that isn't previously in the record before the Luho is new evidence. And so I just want to make sure that everyone understands that allowed before this board is evidence that was presented to the land use hearing officer. Anything that wasn't stated to the hearing officer or presented to the hearing officer can't. Thank you.
Thank you, Mr. Clark. And yes, Mr. Brown, unfortunately, you're not able to present any new information to us today. But thank you, Mr. Clark, for that clarification.
Okay, so no follow-up questions. All right, thank you for your time.
Board members, any questions of Mr. Brown? Seeing none. Mr. Pressman, would you like a rebuttal?
Thank you, Mr. Chairman. Thank you, board members. I'd like to clear the record that the site is not under violation by Hillsborough County. And I showed you one slide that showed that the complaints of noise have been removed and the middle variance about planting have been complied with. I'm sorry, Tom?
Yes. Excuse me, Mr. Chairman, are you going to provide an opportunity for staff to provide comment?
Yes, sir. Would you like to do that before Mr. Pressman?
Yeah, that
or
should
after?
occur before Mr. Pressman's rebuttal.
Yes, sir.
Thank you. Yeah, no problem. Thank you. So a couple of things. One, the staff report that was prepared, the request was summarized as the applicant is requesting setback and landscape buffer and screening variances for existing commercial structures on the property zone CG. This staff report was available for Mr. Pressman's review at least a week before the hearing. I am not aware that he contacted a case planner or myself to correct the report if he felt that the statement was incorrect. Also at the hearing, I do not recall nor reviewing the transcript that he expressly corrected the report. Secondly, there are some comments I want to point out to you in the transcript. So one is going to be on page 1.A.33 of your backup. And it's Mr. Pressman talking to the hearing officer. And he states this is a long-term configuration, a multi-decade situation with the conditions that we propose right on State Road 60. We do feel that the application is absolutely approvable and meets the criteria. It's not injurious or detrimental to any other properties in the immediate vicinity that we're aware of, and allowing the variance would allow the continuation of use that is similar to others and has been there for many, many decades. Later on in the hearing officer is speaking to Mr. Pressman's client, who is Mr. Farmer. And Mr. Farmer states in dialogue with the hearing officer, says the building that we're in has been there 25 to 30 plus years on the property line. It's not like we put it up. It's been there 20 to 30 plus years. And when you see stuff at nighttime, it's our guys coming in at nighttime off the road, and we're just backing it in and leaving the facility. And so there, several times throughout the course of the hearing, there was references to the existing conditions on the site. However, at the end of the day, when you look at the hearing officer's decision, right, for the different findings of facts for the 6 criteria, her findings in fact for every one of the criteria makes reference to the demonstrate that the existing commercial building has been in this location for many years and well before purchase of the parcel by the current property owner. That was for number 1. Number 2, the application in the LDC would not recognize the location of the commercial building, which has been in its current location for many years. Criteria 3, the variances for the setbacks are the result of the location of the existing commercial building, which is shown to have existed in its current location for many years and prior to the purchase of the property by its current owner. Number 4, then her response, the commercial building has been on site for many years on commercially zoned property fronting State Road 60. Number 5, the lot shape and location of the commercial building existed prior to purchase by the current property owner. And then number 6, yes, the granting of the variances served to recognize the existing commercially zoned lot and commercial building. So when we were approached by Mr. Pressman and his client as to whether these variances would be applicable, to a new redevelopment of the site, we responded no. And the basis of that is that throughout the hearing officer's findings, he makes repeated references to the existing commercial buildings on the site. Thank you.
Thank you, Mr. Hisney. Does the board have any questions for Mr. Hisney? Okay, seeing none. Mr. Pressman, I rebuttal now, sir.
How much time do I have, Mr. Chairman?
I believe, Mr. Clark, can you help me with that question? Is there any?
Well, I won't take too long.
Yeah, I believe it's 5 minutes. Is that correct, sir?
Rebuttals are usually shorter than initial presentations, so 5 minutes is generally
Yes,
correct.
yes, sir.
Go ahead, sir.
If you can keep it to 5 minutes, Mr. Pressman, that'd be appreciated.
Yeah, 5 minutes at most. First of all, let me put on record that the site is in compliance. The site was being reviewed by code enforcement. They met compliance. The use that's been there and there now was never in contention. It's allowed by, it's permissible by zoning. With all due respect to the neighbor, he's had some limited conversations with the property owner, what his business plans are, and there's a lot more to it than that. Mr. Hisney gave the contention that I had not communicated what this variance was about. If we go to the overhead, please. Our submittal had nothing to do with the commercial structure. Staff picked that up. Staff was the one that started to inject it. At the beginning, she repeats it. And however, again, when I state at the hearing what we're requesting, she has my request without the commercial structure. So here's 1 instance, 2 instance, 3 instance. Here's a slide. Here's the 4th instance of what we're requesting and deferring the staff is wrong, showing what our variances are. It can't be more clear than that. That's the 3rd time. And then the 4th time, which the hearing officer accepts and writes up, is here. So the contention, Mr. Chairman and board members, that we didn't clear the record or present the record what we're asking for is, with all due respect to Mr. Hisney and the hearing officer, is absolutely incorrect. It couldn't be more clear. Verifiable by demonstration of these points. So when Mr. Hisney goes through a step-by-step review of the criterion, she does refer to the commercial building, but she also critically, as I've read to you and shown you many times, is that she recognized the basis of the variance is the width of the property. I'm not going to beat the dead horse on that. But here's the critical point, that she recognizes the shallowness of the property, but her conclusion is false because she only recognizes it for one point. That makes no sense. That doesn't address the variance that she recognized, or the difficulty or hardship that she recognized. That's virtually, I would say with all respect, most of what you need beyond her recognizing all the criteria. What she approved did not line up with what she recognized as the shallowness of this property. We appreciate you all being here today. We appreciate the resident being here, and we appreciate your consideration. This property needs your help. It will be unlike virtually every other property on Brandon Boulevard as reported to by the hearing officer. Thank you.
Thank you, Mr. Pressman. Board, any final questions for Mr. Pressman? Seeing none, we'll bring it now back to the board. Just real quickly before Mr. Clark, just to make sure it's clear to me as well as the board members. So basically, the two potential decisions we could make sure I am correct here, sir, is that we remand it back to the LUHO because we disagree with her not acknowledging the reconsideration request. So we find that in error. That's why we'd be remanding it back. Or we don't do that and we uphold the finding of not rehearing and things stay as they are. Is that correct, sir?
So to clarify, sir, as far as the uphold and the remand, you're correct. Those are the two options that are available to the board because this is the first time that this case has been before. However, to clarify, what you are reviewing is not it's not an appeal of the motion for reconsideration. It's an appeal of the denied. I believe Mr. Pressman said in this record, he's not appealing the variance that was granted. He's only appealing the one that was denied. So and just to clarify the motion for reconsideration part, there is a occasionally used provision that regulates hearing officers when they are rendering decisions on variances or special uses, where an applicant who has had a ruling go the way they do not wish can move for reconsideration to consider that there's some sort of factual error in the record, or it's a fairly narrow standard. The hearing officer is able to grant every hearing to consider what is supposedly have been a mistake or error. That was denied, and so after that, they can appeal to this board. The appeal to this board is appealing the hearing officer's variance denial. If there are 6 variance criteria, the hearing officer made a finding on each criteria. If a variance can only be granted if the hearing officer finds in the affirmative of all 6 criteria. So what you'd be reviewing here today is whether procedural due process was followed, and I haven't heard any arguments from Mr. Pressman that was not the case. Whether there was competent substantial evidence entered into the record before the LUHO to support conclusions of the hearing officer. And competent substantial evidence is any evidence that a reasonable person could utilize to reach a conclusion on something. And finally, that the essential requirements of law were followed. So what you'd be doing here is, if you look at the hearing officer's decision and you believe that there is evidence in the record to support the hearing officer's decisions, you can uphold that determination. And if you find that there is not competent substantial evidence in the record to support some or all of the hearing officer's determinations, you can remand to the hearing officer to allow for another hearing on the issues that you would address and enter into the order. So if, for instance, there's an issue on variance criteria 4, you'd be remanding it to consider additional evidence as to that variance criteria. You would need to identify for the hearing officer what it is that they are supposed to review at the remand hearing. Is that clear?
It helps, Mr. Clark. Just one follow-up question, though. So in this situation, my understanding is the petitioner is not challenging the denial. The petitioner is challenging the findings that the LUHO made in support of what she approved. So that's where I'm having a little bit of difficulty, is that the petitioner is saying, we're okay that the screening was denied. They're not challenging that. They made that clear in their petition. But they're challenging that the LUHO stated in her findings of fact for her 2 approvals that she tied it to the existing conditions of the site. That's where I'm having a hard time with this, is that we're not overturning something that LUHO, or not saying overturn, we're not remanding back to the LUHO something that she denied. They're asking us to remand something saying, well, you approved it, but not under the right standards.
So I think to start, I would say if an argument's being taken that a decision of the LUHO was based on something that's not in the record, then that seems relatively textbook that the argument is being made that there's not circumstantial evidence in the record to support a conclusion. Essentially, if it was based on something that's not in the record, then what that means is that it can't be. It would have to be remanded because there's no evidence in the record to support the conclusion. Right? But it might be worthwhile, because that is an unusual argument, just to have the applicant representative clarify very clearly what they're asking for. Because listening to the argument, I understood the provisions about the inconsistency behind the uniqueness finding as to one of the variances applied for, but not to the other. It may be worthwhile to have Mr. Pressman articulate specifically what he's asking to have the LUHO.
Thank you, Mr. Clark. And if you're comfortable with that, or okay with that, Mr. Pressman, to be clear to us what he's asking us to do. Mr. Pressman, can you do that, please?
Yes, Mr. Chairman. If I understood, what we're asking is that the decision of the LUHO be remanded based upon comments that she wrote of what she supported as a variance. Under criteria number 1, the property is narrow and therefore limits the developable area given required setbacks and buffer width. That finding does not address and is not supported by competent substantial evidence that she has in the record to only approve the variance for a point where a barn is. It's inconsistent. The two don't jive. It's not supportable by what she found as competent substantial evidence in the hearing. Upon that basis, it must be remanded. Additionally, an existing barn is not a hardship. She doesn't call it out as a hardship. She just says the barn is there. The hardship, as she states very clearly, is the narrowness of the lot. So we're asking you to remand this decision because her findings, of which she reviewed of competent substantial evidence throughout the entire hearing, is not in line with, does not support her conclusions to only approve it for one particular point. It must be remanded. And we appreciate your consideration. Thank you.
Mr. Chair, may I ask a quick question to Mr. Pressman?
Yes, sir.
I think what I want to understand is, Mr. Pressman, are you seeking for all of the decisions of the hearing officer to be fully reconsidered at the LUHO hearing based on, so I think there just needs to be some clarity, is Do you want the approvals re-reviewed by the hearing officer? Do you want the denial reviewed by the hearing officer? Which, are you talking about all 6 variance criteria for all variances applied for? I think that's the level of specificity in the board's discussion. If they will ultimately remand it, they're going to have to give direction to the hearing officer what to look at and which variance criteria for which variance applied for that the hearing officer is supposed to reconsider for additional evidence.
I would suggest 2 things. Number 1, I would suggest that criteria number 1 is correct. The following criteria where she mentions and refers to commercial building are incorrect, mistake, and not supportable by the competent substantial evidence she accepted during the hearing. The second point I'll say is on page 7 under decision, she says the applicant has satisfied the criteria for approval for the barn and is hereby approved. That decision is the result of the criteria that she went through, which were falsely or incorrectly presented. So I would say criteria number 1, criteria number 1 is correct. The following are incorrect and should be sent back to the Lujo, and depend upon Mr. Clark, his consideration on page 7 under decision, where she refers to the barn. I would just float that as a second possibility, depending upon Mr. Clark's review and expertise.
Thank you, sir.
So, Mr. Chair, just for purposes of the record, the responsibility here is going to be to determine if you believe there's competent substantial evidence that was entered into the record before the hearing officer that supports that upon which the hearing officer could rely to reach the conclusions that she reached and to reach the decision that she reached as to each of the variance criteria. What Mr. Pressman's presenting today is argument on the record, but it's nothing, there's no new evidence, obviously. It's argument on the record, and of course you've heard that argument. Your responsibility will be to determine if there was competent substantial evidence entered into the record before the hearing officer upon which she was able to rely to reach her conclusions in her decision.
Thank you, Mr. Clark. So with that, I'll bring it back to the board. Do I have a board member that'd like to comment, make a motion?
Mr. Chairman, I believe that the hearing officer did have competent substantial information and evidence before them when they delivered this this determination. So I'm going to move that we uphold the hearing officers to approve variances, which include the existing operation structures on site. And as far as the denial, uphold the denial on the third on the buffering, which is not being contested today.
Thank you. So we have a motion by Mr. Campbell to uphold the Lujo's decision. Do I have a second of that motion?
Yes, I second it.
We have a second by Mr. Schwartz. We have a motion and second. Do we have any other discussion? Mr. Evans? Okay, I have no additional comments either. So with that, we'll move to our vote. And I will start with Mr. Campbell.
I vote to approve the motion.
Mr. Evans?
I vote to remand.
Mr. Schwartz?
I vote to approve the motion.
And I also vote to approve the motion. So with that, we uphold the Lujo's decision by a vote of 3-1. Thank you very much, Mr. Pressman and Mr. Brown, for coming this afternoon. And Mr. Hisney, I don't think we have any other cases. And our last item of business is approval of our minutes from December 10th, 2021. Any comments or a motion?
I'll make a motion to approve the minutes.
Thank you, sir. Mr. Evans makes a motion. A second.
I'll second.
Mr. Campbell, second. We'll just do this. All in favor? Aye.
Aye.
We'll just do all. Unanimously approve the minutes for December 10th. I see that we have no more business before our board. Is that correct? I hear nothing, so I believe that's correct. With that, we will adjourn our meeting today. Thank you so much.